The Policy and Legal Advocacy Center has called on the National Assembly to treat passing the new electoral bill as a matter of national emergency. It is calling for a special session in the shortest possible time, irrespective of the end-of-year break, to consider a vote for the passage of the bill. In a statement, the center said President Buhari's veto and any further delay pose a serious threat to the conduct of the 2023 general elections. It wants the National Assembly to amend the electoral bill to reflect the president's singular concern with direct primaries in order to save the other landmark reforms over which the president has expressed no worries. This includes legal backing for the use of voting devices and the electronic transmission of results, as well as improved voting procedure for persons with disabilities.
Well, for more on this, let's now bring in Queen's Counsel, Senior Advocate of Nigeria and President of the Nigerian Branch of the International Law Association, Fidelis Oditah. Well, he joins us from Lagos. Thank you so much for joining us tonight on the program. And I'm really excited to have you and looking forward to, first of all, let's get your reaction to the scenario that has played out, especially in the last 24 hours with the president, withholding his assent to that all-important bill. And of course, the scenario in the National Assembly, especially the Senate and the House, as it played out today.
Thank you, Amaka. It's very sad indeed that President Buhari had to wait for 30 days before communicating with the National Assembly that he was going to withhold his assent to this very important and in some respects landmark bill that was sent to him, which would have introduced a number of very important reforms into the conduct of elections in Nigeria, and as the Speaker said, instill or restore public confidence in the conduct of our elections. The reasons that he gave are far from convincing. He referred to manipulation, but everyone knows that the current system of indirect primaries is riddled with manipulation and godfatherism. He referred to security challenges, but he should be ashamed of that reason, because as the chief security officer of the country, it is his responsibility to make sure that direct primaries are conducted in an atmosphere which secures the participants. He also referred to high costs, but there is no evidence, empirical or otherwise, that the direct primaries will be more expensive than the current godfatherism where lots of monies are shared between a very select few. And then he talked about marginalization of small parties. He did not elaborate on what he meant by that. He also talked about litigation, but all of us know that the existing system encourages litigation more than anything else, because there is always disagreement between those who are supposed to have won the primaries and the so-called candidates who are imposed on the parties. And this is why we have a lot of pre-election litigation. So it is very difficult to understand what President Buhari and his handlers are saying in relation to the electoral amendment bill.
Well, Queen's Counsel Oditah, I want to quickly say that because you're one Nigerian that holds such a dual position, SAN and Queen's Counsel. But amongst the several objections of Mr. President is the one that even says, would those objections be seen as, unconstitutional, and will it likely undermine democracy? What are your thoughts here?
I don't think one can talk meaningfully in terms of unconstitutionality of his objections. He has a constitutional right to assent or to withhold assent without giving any reasons. He's given reasons which we consider to be bad reasons. Obviously, the National Assembly will now have to consider its position, whether it wants to take the issue head on by seeking to override the veto, or alternatively tinkering with the bill to remove the bits that the president has found objectionable. What is perhaps amusing is that he wrote to a number of parastatals, including INEC, without drawing their attention to any specific objection. He simply asked for their views. And as far as I'm aware, INEC did not say that direct primaries were going to cause it any difficulty at all. And indeed, it is difficult to see how it could cause any difficulty. I don't know how many members there are in various political parties, but I dare say the Bar Association only last year conducted its own elections using electronic means. And I don't see how the use of electronic means by political parties can cost them anything near the 500 billion, which I think the president and his handlers planted in the press so as to disparage the electoral amendment bill.
Right, just to be clear on your position on what Christian had asked you, you disagree with Mr. President that, you know, this direct primaries actually violates the constitution of political parties as constituted. I need to get that clarification. And also, what were the other options that were available to Mr. President? I ask this because if you look at the situation with the PIA, the president did assent to it, but he picked holes on some issues that he felt, you know, work could still have been done there. So what were the options that were available to him, you know, aside from withholding his assets, which he eventually did?
Yeah, first of all, he could have asked the National Assembly to reconsider some of the issues which he claimed were troubling him. The PIA is a special legislation because, you know, that had almost a 20-year parliamentary history. And it was clear that President Buhari, wanted it. So he made more effort to get it to a stage where he could assent. But to address the other point you made, which is in relation to interfering with the democracy of political parties, as we see it in Nigeria today, the main difficulty that the system has is a lack of internal democracy within the political parties. So if you look at Lagos or many of the states, what you see is imposition of candidates. And that is a negation of the so-called spurious democracy that they speak about. But beyond that, INEC has the constitutional power to regulate political parties. So I don't see a problem at all with INEC telling the political parties how they should conduct their primaries. Besides, if you look at the existing Electoral Act, it gives the option of direct or indirect primaries. What the current amendment seeks to do is to take out the option of indirect primaries because the evidence shows that the political parties have abused that particular option. And they have imposed autocracy and they have imposed undemocratic principles in the selection of political parties. You remember in 2007, for example, so many candidates were substituted willy-nilly by political parties for no reasons. You win your primaries and then you find that the chairman of your party has submitted someone's name even without consulting you. How could that be more democratic than direct primaries?
Well, if you have to advise the National Assembly, you know, on the way forward, what would your advice be to the lawmakers, particularly where some Nigerians feel that the National Assembly is too tied to the president's apron string?
I think it depends on whether you want to confront the issue head on. If you want to do that, the solution is to muster the 2/3 majority to override the veto. As you mentioned in your intro, this was done in relation to the Niger Delta Development Commission bill in 2001 because President Obasanjo did not want to assent to that. He withheld his assent, but the National Assembly at that time overrode the veto by mustering the 2/3 majority. So that's the first thing that this assembly should consider, whether they can find sufficient numbers of people of courage and conviction to pass the amendment bill in its current form and therefore override the presidential veto. That would require maybe about 73 senators and possibly 240 something members of the House of Reps. That's the first solution. The second one is to seek a compromise. If they cannot find the 2/3, and I see that that might be difficult if the PDP members of the National Assembly who were opposed to direct primaries in the first instance decide not to support. In that situation, they would then need to remove the direct primaries because there are a number of other salutary provisions in the Electoral Amendment Act. For example, the BVAS, the bimodal verification, the bimodal accreditation method, where if the fingerprints fail, you can use the iris or the eyes to identify a voter. And we saw the magic that that produced in Anambra State, from local governments where over 200,000 people were registered on the electoral register. We saw less than 13,000 coming up for vote. So that will eliminate a number of ghost voters and introduce credence and credibility into our electoral process. There's also the issue of the electronic transmission of results, which was much debated in the media. I think that at least those two, the BVAS, which they use in Anambra State, and the electronic transmission of electoral results, are good enough for them to try and preserve in the event that they are unable to find the 2/3 majority. But in saying that, I must also emphasize that I find INEC's position somewhat weak, because under the existing constitutional arrangement, INEC has the constitutional power to undertake, organize, and supervise elections in Nigeria. And it seems to me that those words are extremely wide. They include and must include the power to determine the devices to use to accredit voters. They must also include the methods to use to transmit results. I think that the difficulty that INEC might have encountered in this respect relates to the very peculiar decisions of some of the judges who have failed to understand the width of the constitutional language and have sought to subject Nigerians to the tyranny of verbosity, where unless you find something specifically spelled out in the legislation, they will hold in their infinite wisdom, or lack of it, that INEC has no power. If I were a judge and I am faced with a constitution which gives INEC the power to undertake, organize, and supervise elections, I would need no other power for them to use BVAS in accrediting electors who come to vote, or in transmitting results, because those words are extremely wide. I cannot imagine wider words, and I cannot see what INEC would do which cannot be captured by undertake, organize, and supervise. But be that as it may, the courts have taken us, not for the first time, to almost the abyss by insisting that unless you find everything spelled out in black and white, there is no power. I find that approach to construction of the Constitution and to construction or interpretation of other legislation very, very strange.
So, from what you're saying now is that INEC has a very, very wide latitude as guaranteed by the Constitution. If I may ask, from your position and knowledge of the law, can INEC ask the political parties to direct them to conduct direct primaries?
I don't see why not, because INEC has the power at the present time to make rules to govern political parties. Those rules could require them to conduct direct primaries. But I think the difficulty that INEC might have under the existing legislation is, I believe, Section 87 of the Electoral Act, which gives the option of direct and indirect. And I think in those circumstances, the courts, which are very anxious to set aside acts done by INEC might take the view that where the primary legislation has given the option of direct or indirect, INEC cannot take away that choice by purporting to exercise superior rule-making powers.
Right. Thank you so much for that clarification. And of course, let's look at the fact that I want to first of all get your take as to how, the scenarios played out in both houses at the National Assembly today, with the Senate, still remaining mum in terms of what they intend to do next. And of course, we've seen the Speaker of the House of Representatives saying that they are going to rework it. I want to get your take as to what you make of, the scenarios today. And also, let's compare Nigeria's democracy and how it's being practiced. Compare that to other democracies, especially looking at international best practices when it comes to democracy.
Thank you. The problem that we have in Nigeria, both the problem of corruption, embezzlement, abuse of public trust, insecurity, they all boil down to the fact that we don't really have a democracy. The people who are exercising power in our names are not, with all due respect to them, or to many of them, or in fact to most of them, they were not properly elected. They were selected by processes which are undemocratic within the political parties. Most of them rigged elections. And so, against that background, it must be in our interest, our collective interest, to rescue ourselves from the near state capture which we are feeling at the moment, where the politicians, it's like what I often say about the lunatics taking over the asylum. We're trying to regulate the politicians and to ensure that those who exercise public power in our name are actually elected by us, and they do have our mandate. But at the same time, those same people are the ones who are making all the rules and making things as easy as possible for themselves and creating all the loopholes for manipulation. Now, looking at what the National Assembly said today, it is clear to me that the National Assembly does not have the courage or conviction to try a veto, certainly not this National Assembly. I saw the Speaker saying the President, it is not proper to throw the baby away with the bathwater. Of course, that is a conciliatory language. It suggests to me that what the House of Representatives are likely to do would be to see how they can rescue the bill by removing the issue of direct primaries. In relation to the Senate is even much weaker than the House of Representatives. I do not see any circumstance that the President of the Senate will confront President Buhari. I really do not see it. Otherwise, all these debts that the National Assembly has been lumbering the country with would not have happened. If we had the modicum of independence among the leadership and even the followership in the National Assembly, we would have a much better, much stronger, much fairer democracy. But unfortunately, and as often said, people get the leadership they deserve. We're in the most unfortunate position where a few people have captured power, not democratically, although they have seemed to have gone through a semblance of democracy, but we know that most of them have rigged themselves to power. And this is our attempt to rescue the country from the brink of total collapse. And you can see the problems. You don't need to ask anyone. Look at the insecurity. So it is laughable for President Buhari to tell us that one of the reasons why he vetoed direct primaries is the security challenge, where he is the chief security officer. And one of his 3 programs is to tackle insecurity. But we have had the worst insecurity under President Buhari. No one can go from Kaduna to Abuja by road. And in many parts of the country, there is banditry. But those are all expressions of collective frustration. Whilst we don't encourage any form of criminality, we must acknowledge the fact that the insecurity, which has almost overtaken the country and certainly enveloped several parts of the country, is directly attributable to lack of leadership or to a failure of leadership, which itself is due to the questionable ways that some of his leaders came to power.
All right, that's Fidelis Oditah, Queen's Counsel and Senior Advocate of Nigeria. Time will not permit me. I wanted to ask you if really there's still hope for electoral reform, considering the time frame between now and 2023 general elections. But nevertheless, thanks very much for shedding more light on the electoral bill.